Well, hello there, my friend. Welcome back to the channel. Thanks for being here. Holy cow. What a great day. Today has been a great day. You know what? Well, first of all, I know what you're asking yourselves right now. You're asking, Gavin, why is your shirt screaming at me? But it's not screaming angrily at you. These are happy screams. Happy screams. Okay? Number two, you know why it's a great day? Today is the 23rd anniversary of the birth of our second born, our first boy. It's a good man. He's a good young man, working really hard, and hopefully he's had a great birthday. I've given him lots of squeezes. Kimberly and I have given him a good gift. He's a good guy. It's just, isn't it great to watch your kids grow up into adults and like them as adults? Pretty amazing. Anyway, great day. Okay. You know why else it's great? It's because you and me, we're here together. We're here to cut through the fluff, cut through the sensationalism, go right to the nitty gritty of true crime. That's what we do here. If that's your deal, glad you found us. We are talking about the case of Madeline Soto. And for some reason, I don't have the buttons up yet. Here we go. There we go. We're talking about Maddie. Little Miss Maddie. Now, what we're really going to be talking about now is kind of the legal doctrine that is at the center of a motion to suppress that I think is super important. But before we get into that, let's just quickly summarize why we're here, okay? Madeline Soto was 13 years old. She had just had her 13th birthday party when she went missing. It's crazy. She just went missing out of thin air, missing. But what police say really happened is that this man, Stephan Stearns, murdered her. They've arrested him for her murder and also for his continual, prolonged 5-year SA of his on-again, off-again girlfriend's daughter, Madeline. And that's the case that we're talking about today. Okay, there's a link in the description down below. You can get to the Osceola County Clerk of Courts. You can see everything that we're going to talk about today. But I think where we want to start before we really get into the motion itself, I'll show you the motion. I think what we want to do first is talk a little bit about the Fourth Amendment. Because if you read the title to this video, you will have seen that I think maybe the defense has something here. So let's talk about the Fourth Amendment. Let's keep Maddie's face on the old screen while we do so, okay? Fourth Amendment, I'm going to bring it up on my screen just so I can read it real quick. It's brief. It says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That is what the Fourth Amendment says. Now, in a nutshell, the Fourth Amendment protects us as citizens of these United States against unreasonable searches and seizures. Now, when our founding fathers, who were brilliant and learned and also normal dudes, all dudes, wrote the Constitution, I imagine that none of them, maybe Ben Franklin, no, not Ben Franklin, nobody imagined that one day all of us would be parading around with little tiny devices that holds the power of the world in them. I'm sure that they did not see that coming. They were living in a world where the crown, the sovereign of England and his agents were going about abusing the colonies, and they wanted to protect against that, right? However, there's a lot of case law on our cell phones when it comes to the Fourth Amendment. Just realized that I did not put my do not disturb on. Okay. Generally speaking, the search of a phone requires a warrant. And that is established case law in a United States Supreme Court case called Riley v. California. It's about 10 years old. So if a police officer conducts a search warrant, or conducts a search of a phone without a warrant, or at the very least without one of the enumerated exceptions like consent, it may be unconstitutional. Now, consent in this case is, we're going to listen to it, and then we're going to read the document. But let me just go over this here real quick. There are some key issues at play. Okay, the scenario is that a police officer wants to see something on your phone, and they ask for something very specific. Hey, I would like to look at the settings for TikTok. May I do that? And you say yes. They take the phone, they go, well, there are the settings for TikTok. Oh, but wait a minute. While I'm here, let me just browse around a little bit. Hey, I just found something illegal. Well, I didn't consent to that part of it. I only consented for you to look at the settings for TikTok. And that is what the question is here, is did Stephan Stearns give consent for them to look through his phone, or did he give them consent to do a very specific thing? And this is very important, guys. So the first question is, was there consent? So in my opinion, there was only consent for the officer to take a look at the settings to see if Google was connected. Now let's listen to this real quick. Okay, here we go.
I barely know how to work it myself.
I'm an iPhone person.
No.
Is it okay if I go in your settings real quick? I just want to see if you're logged on to your Google.
I am not logged on to my Google with that, actually.
Is it okay if I check?
Yeah.
Okay, so she asked specifically, can I go into your settings? I want to see if you're logged into Google. He says, I'm not logged into Google. Can I go in and check anyway? Yes.
Does she have any other devices besides that?
And then that's the end of that part of the conversation. The detective, when I say she, the detective has said, I want to look at your settings. Can I do that? While she's in there, what appears to happen is the other detective starts asking other questions, and the first detective starts looking around, nosing around. And that brings us into the second part of it, which is the plain view doctrine. Okay? The plain view doctrine, basically, and I know a perfect example here. The plain view doctrine is, okay, so say I get consent to go inside your house. I have got consent to just stand in the doorway. You've invited me in as a police officer. And as I'm standing in the entryway, in plain view, I look over, through a hallway into the kitchen, and I see drug paraphernalia. Okay, now that is in plain view. So, one, the officer was legally in a position to see that. The stuff that they see was incriminating in nature, and therefore they did not violate the Fourth Amendment. Now, they may still, in fact, they do almost all the time to protect their case, apply for a warrant at that point. But that's not what happened here. The phone, she had to go through things on the phone in order to see the things that she saw. What we just listened to happened on the 27th in the early morning hours. Let me just play this little bit, because later on in that conversation, she goes, I'm going to keep the phone. I'll give it back to you when I give it back to you. Okay. Later that night, it's like early the next morning. Listen to this.
Can you explain to me what your relationship is between you and...
Yeah, stepfather of sorts, I guess. She thought of me as a dad, thinks of me as a dad. Mostly things like When are you going to call us? When are you going to come up here and visit? Hey, poopy head, get online. Things like that.
Okay. Sorry, I don't mean to cut you off. Your phone. I told you that I was going to hold on to it and that we would like to download your phone, right?
Okay.
Is this something that I have your consent to do, or do I need to get a search warrant for your phone?
It should be fine.
You're okay with us going through your phone?
Yeah.
Okay.
Okay, now here is the thing that's really important here is that they had already gone through the phone when she asked that consent. They had already found the stuff. She's now asking for consent, I think probably to cover her hind end. Okay. Now getting back to our conversation, there's the consent issue, there's the plain view issue. Now the next question is the warrant tainted? Okay. So if the officer only learned about the incriminating evidence on Mr. Stern's phone by exceeding the scope of the consent that he gave her, or by otherwise violating her or his rights under the Fourth Amendment, and then used that knowledge to obtain a warrant later, and they did obtain a warrant later, then the evidence discovered as a result of the warrant may be suppressed under a doctrine called fruit of the poisonous tree. That doctrine came about in a 1963 case it was a federal case, Wong Sun versus the USA. The idea is that if the source or the tree is tainted, so is the fruit. Okay? So the question here is, I think the last part is, can the officer show that the warrant was based on lawful evidence, or that they could have gotten to that evidence inevitably anyway? Then they might be able to uphold. The prosecution might win. Hopefully that helps. So basically what I'm telling you here is, I think there is a very, very good possibility that Stephan Stern's legal team might win this motion. Let's go over to the motion itself, okay? All right. You guys probably don't want to hear that. In fact, before we really get into the motion, let's bring Maddie's face up again. Let's go over to your comments real quick. Just see where you guys stand right now. Because my issue, the thing that I care about most here, we care about Maddie. She's the most important thing, right? Second to Maddie is the fidelity of the law. And if police made their case on evidence that was collected illegally, then that is on the police. It is their fault, not the lawyer's fault, not Stephan Stern's fault that he would get to walk in that scenario. It would be the police's fault. And I've told you that I think the police did a very, very good job here, but this is a problem. It 100% is a problem. Okay. Mooney says, Gavin, say it ain't so. The Google Drives need to come in. Yeah, I think that they will have a hard time making their case in the SA case without it, for sure. Let me sneak on down. Let's see. It's going to have to refresh here. Give me a second. There we go. All right. Kimberly likes my shirt. I like Kimberly's name. It reminds me of somebody that I love. Happy birthday to number 2 son. Yes, indeed. Yes, indeed. Shay, thank you kindly. Joy, thank you kindly. You guys are always so complimentary. I love it. Let me keep on going. Holy cow, Bonnie has a 53-year-old son. Yeah, they never grow out of a parent's love, do they? Never do. Okay, here we go. Oh, One Man's Trash. Thank you very much for the super sticker. Most kind of you. Okay, Phoenix Rising says, but Gavin, he authorized the search of the phone because he thought he was smarter than a 5th grader when he accidentally factory reset it. Well, that is the question, right? The question is, did he authorize the search of the phone, or did he simply authorize them to look at the settings of the phone? And I think there is a good case to be made here that is the only thing that he consented to until later, which we heard he said should be fine, go ahead and download it. But they had already, if the defense is correct, they had already gotten the fruit of that poisonous tree. That's the scary thing here. Super charismatic. They found that stuff on the hard drive that his dad gave them too, right? I'm not sure. I can't remember what was on the hard drive. I think that basically the savior here is going to be, would they have gotten there anyway? Or was there some other way for them to get there and would have been inevitable? Which I think the prosecution can make that case. Sandra says, sad part is if this gets thrown out, no case for the DP in the other trial, and most likely he walks free. Well, yeah, DP is on the table because he committed, they're saying, the murder also in the commission of another felony, right? But I still think they have a case that could be made for the murder. They just might not get DP. And you know what? There's always a chance that the defendant can walk free. That is why it is so important for police and prosecutors to walk that narrow line perfectly. And it's a hard burden. It's a difficult burden. I thought she asked 2 different times. We're gonna get into the argument that they made. Once she had seen what was on the phone, she said, I'm keeping the phone. And the second time she asked was after she had already seen everything. And Corina brings up the same thing, but didn't they ask again when they took possession of the phone? Yes, they did. But again, they already had, if the defense's argument is right, they already had that poisoned fruit. All right, let's see. Horror Queen says, Gavin, it baffles me that he thought doing 2 factory resets was going to hide anything illegal. He acts like his generation, mine too, didn't teach our parents how to use the smartphones. Yeah, that was good. Sarah says, so was it truly logged out and then she logged in from a saved password login thing? No, I think it was logged in. Oh, well, that's a good question, actually. Was it already logged in? Or did he have passwords saved on his phone? We're gonna read the argument. That is a great question. Precious Culp, Gavin, but didn't Eeyore give consent during one of the interviews with detectives to have his phone to search it? Yes, but it boils down to the timing. The question is all about the timing. All right. Kimberly says, Gavin, where does probable cause come into play? If she has probable cause, is she not allowed? If she had probable cause and she can make the argument that the probable cause existed for her to continue to search the phone, then that side would win the motion. Good point. Yeah, this is legal doctrine. And by the way, I'm not a lawyer. It's funny. Not a lawyer here, guys. True Crime Addict says, Gavin, he was thinking he was consenting to a phone, but that was set to default. He didn't realize they could find what he had in Google Photos and Google Drive. It does appear that is the case. Indeed. Susan says, I agree with some of your argument, but the prosecution will argue inevitable discovery. Indeed. With all the video evidence they had, the phone would have been seized by warrant. Yeah, I think you're right. That's the argument that they're going to make. The question is, will the judge buy that? Because there are things that investigators, both on the policing side and the prosecution side, that they do that drive judges crazy because it endangers the law. It endangers the fidelity of the law. So I think that in a case like this, the judge likely is going to side a little bit over on the defense if there was impropriety. And I know of a case in New York State where it became a problem. This was one where a woman had escaped a captor and was able to guide police back to the house where she had been held captive. And while in the house, in a part of the house that they didn't need to be in, that was nowhere in her comments to them, in her reporting to them, they saw something and then applied for a warrant, and it became a problem. They were fortunate that the defendant pleaded in that case. Anyway, great comment. That's a good place to pause. Okay, your comments. Let's head on over to the actual document and take a look. Okay, this is the motion to suppress. I believe it is signed by Ms. Vickers in this case. Yeah, okay, so let's go up to the top. Here we go. Motion to suppress evidence obtained from unlawful seizure of cell phone. By the way, there are two motions. One to suppress evidence obtained from the unlawful seizure. One to suppress evidence obtained from the unlawful search. I'm just going to do this one tonight. Okay, we might go over the other one in a future video, but let's have a look. Okay, comes now. The defendant, blah blah blah. Introduction. This case presents a flagrant violation of Mr. Stern's constitutional rights under the Fourth Amendment and Article 1, Section 12 of the Florida Constitution, which I did not look up, but I believe that it probably applies. Detective Tagler with the Orange County Sheriff's Office unilaterally seized Mr. Stern's cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported consent for its forensic examination. Because this seizure was unlawful and all evidence obtained bears the taint of this initial illegality, the court should suppress the cell phone evidence and all derivative fruits. Again, fruit of the poison tree doctrine, right? This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Stern's phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. And again, this is a good argument because they did apply for and get a warrant to search Mr. Stern's Google account, which they would not have been able to do they would have not known to do had they not seen the evidence, which this lawyer is arguing is tainted. It is poisoned. Evidence to be suppressed. Any and all tangible or intangible evidence obtained contemporaneous to and following the illegal seizure of Stephan Michael Stern's cell phone, specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. They say that he has standing. They always have to do that. Burden on the moving party. The moving party, that would be the defense, the moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. And indeed, not only did they report it, but they released it publicly. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. Okay, statement of facts. On February 26th at approximately 8 p.m., Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. On the 27th, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. This is an indication of what the defense is going to be. I'm telling you, the defense is going to be, my client didn't do it. She done did it over there. That's what it's going to be. She's not going to have that accent, but it just felt like it needed that accent. Detective Myra Tagler of the Orange County Sheriff's Office was assigned as lead investigator. On February 27th at approximately 4 p.m., Detective Tagler, accompanied by Detective Acosta, contacted Mr. Stearns at his residence. The detective's interactions with Mr. Stearns were audio recorded and captured the exchanges between law enforcement and Stearns. We just listened to snippets of those, right? Mr. Stearns' residence is located at 4012 Santa Maria Drive in Kissimmee. Detective Tagler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check if his Google login status, by asking, quote, "Is it okay if I go in your settings real quick? I just want to see if you're logged onto Google." Now, why would she do that? My belief on that is she would do that simply because her experience is that people who she suspected Stephan Stearns of being tended to store stuff on the Google Drive. Her experience would tell her that. And that is probably why she wanted to see if he was connected to Google. She's a good detective. Just like what she should have done is gone, "Hey, can I check to see if you are connected to Google? Hey, you are connected to Google. Can I take a look at your Google account?" Stephan would have been so dumb. "Yeah, sure. Go for it." Or he would have gone, no. And at that point, she could have seized the phone because she had probable cause to believe that there was something that he was hiding and she could have gotten a warrant. That's the reality. But she skipped that second part, in my opinion. Okay, Mr. Stearns responded yeah to this specific and limited request. After exceeding the scope of this limited consent, Detective Tagler unilaterally announced, "I'm going to hold on to your phone and I'll give it back to you when we're done." Illegal. That is illegal. According to me, non-lawyer. Okay, I think that there had to be that next step first. The trying to get permission to see the Google account. Stephan Stearns, if he was smart in that one moment, would have gone, no chance. And he probably would have gone to try to cover his crime, but it would have been able to be found. Okay. Mr. Stearns expressed explicit concern about maintaining contact with his father through that phone. Detective Tagler dismissed Mr. Stearns' concerns by stating they could call Miss Soto's phone instead. Yeah, that's my memory of it too. Mr. Stearns was given no choice regarding the seizure of his phone. No consent was sought for the seizure of his phone. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. The detectives did not present Mr. Stearns with a written consent form for the seizure. The detectives did not advise Mr. Stearns of his right to refuse consent. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. The detectives did not document any exigent circumstances justifying the warrantless seizure. I did go and look at the arrest warrant. I agree with paragraph 18 here. They have not documented any probable cause or exigent circumstances that they believed they had in order to continue to search the phone, in my opinion. On February 28th at approximately 1:30 in the morning, detectives again contacted Mr. Stearns. That is the second recording we listened to. The second contact occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, I told you that I was going to hold on to it and that we would like to download your phone, right? She did not say we wanted to download the phone. She said we were going to hold on to it, to my memory anyway. The detectives presented Mr. Stearns with an ultimatum. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? By the way, let's pause here for a second. Kids, oh my goodness. Never, ever, ever give consent to police to search anything. Ever. Now, I'm glad that there are stupid criminals like Mr. Stearns. Let's put up his face here real quick. There he is. Oh, no, not that one. Let's do this one, okay? I'm glad that stupid criminals exist, but you and I are not stupid, nor are we criminals. Never, ever, ever give consent to police to search or seize anything. Period. This message has been brought to you by Uncle Gavin. Okay, let's continue. Yeah, always just say, yeah, get a warrant. Always. Every time. You know, the reason that people like Stephan Stearns say, no, it should be fine, is because he doesn't want to arouse their suspicions. But as you and I have spoken many times, their suspicions are aroused. They go to bed with aroused suspicions. They wake up with aroused suspicions. There should be, you know what? I wonder if Cluvelta helps with prolonged aroused suspicions. I don't know. I don't know if it's been tested for that. By the way, I've noticed that some of you have gone to the merch store and have ordered your Cluvelta merch. We have sold several of the mugs, specifically this one, the Cluvelta mugs. And on the new design, which all of you get who have ordered it, I put what the actual medicine is. It's suspictoline fluorate. Cluvelta is the brand name, you see. Anyway, all right. Where was I? Yes, anyway, they are already suspicious, okay? You are not going to arouse their suspicions further by saying get a warrant. Just make them get a warrant. It's the way it is. Okay. At the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures, which I guess in Florida they consider to be cold. Up here in Pennsylvania, we feel like that is a balmy night. Mr. Stearns was wearing only flip-flops, khaki pants, and a thin hoodie. Mr. Stearns had not eaten all day prior to the incident. I wonder why he didn't have an appetite, by the way. Mr. Stearns was not allowed to return to Ms. Soto's vehicle, which was heated despite the cold weather conditions. Earlier that night, Mr. Stearns had taken Ativan, a prescription medication to manage his panic attacks. Mr. Stearns clarified to the authorities that he had taken the tranquilizers to help him sleep, as he had been struggling with insomnia. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. Ativan is known to cause drowsiness, sedation, and impaired alertness. Mr. Stearns described the effects of Ativan to law enforcement, stating, "This is why I missed your calls. I'm sorry I took Ativan and conked out for a few hours." At approximately 2:40 a.m. on February the 28th, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensics Unit. Okay, that is the statement of facts. We're going to get into the legal argument. Let's head on back to your comments here real quick. I'm going to refresh. And I'm sorry if I missed some of your comments, guys. Let's start here. Alice Martinez says, Gavin, True Crime Addict says, because I don't know the answer to your question, Alice. I don't know if she will be testifying at the trial. We don't know yet. Gavin, that will totally make me sick if he gets off on a technicality. Yeah. I mean, there's a case here in my hometown. I've actually covered it it's on my website. It's from the 70s, where there was so much evidence, just piled up evidence against this guy who was accused of stabbing his lover to death in their home. They never found the murder weapon, but they found mountains of evidence, but dang it, they did not read him his Miranda rights. And therefore, he spent the rest of his life as a free man, and to this day, her murder goes unsolved. I hate technicalities like this. Let's bring up Maddie, by the way. But like, we want our police to do the right thing. We don't want them to run afoul of our rights as guaranteed by the Constitution. Kimberly says, Gavin, she did it because she caught inconsistencies in his story. Google not only stores your photos and whatnot, but also tracks your movements. She may have been looking for his specific movements. Yeah, it's possible, but his movements would not be in Google Photos. See, that's not in plain view. Remember the plain view doctrine? And I'm sorry to be arguing on this side of it. I think that there's a good chance that they win this. I mean, it really boils down to, would they have gotten there anyway, right? Joy says there was probable cause, except they didn't document that probable cause. Great comment. How do you know she got into his Google Drive before the warrant? Because they state that in the warrant application. Let's see. I think it's the phone application and also the Google Drive application, but keep me honest. I believe that is the case. Linda, welcome. Welcome. Also, Boggy Quagmire. Hope, welcome. Glad you're here. Do you know me? Gavin, but they are allowed to lie to you, and they can use what they get even if you waived your Miranda rights and allow yourself to be questioned. Yes, that is true. Yes. Police are allowed to lie to you. You are not allowed to lie to them, though. That is why you just say, I'm not speaking without a lawyer. And then zip it. Okay? The doc says Stephan Cern's address is Jennifer Soto and Maddie's address. I'm not sure if it matters, but he didn't live there at the time. He lived with his parents, right? Does that change anything? I don't know that changes anything. I think that effectively that was where he was living. I think. I don't know. The lawyer's certainly arguing that, right? Yeah, ask for a lawyer, especially when you're innocent. Indeed. Always. Beck is a fan of Kluvelta. Well, the ad. In fairness, Beck didn't say she's a fan of Kluvelta. She said she's a fan of the ad. If any of you have used Kluvelta and you have any testimonials, I'd love to hear those. Let's see. Oh, it just refreshed again. Do we know if the police had the surveillance footage already? I don't off the top of my head know that. Are they going to put the trial on YouTube? The state of Florida does televise trials. It will likely be streamed, yes. Super Charismatic says, am I the only one who learned heartily from Jay-Z that a warrant is necessary? Marco Benavides, I am speaking the truth. Well, thank you for saying that. Beck says the law is in place to protect everybody, even those who don't deserve it. Agreed. Would it be considered probable cause? Well, they will have to ask what the probable cause was if that's what the prosecution is saying. They will have to be able to prove they had probable cause because they didn't document any. If the defense wins this motion, is there any other evidence that supports his SA of Maddie? Yeah, I think the DNA does. Sandra asks, what is Kluvelta? Guys, do we need to take a break? Tiffany asks, what is Kluvelta? We've got new people here. We've got new people, which is terrific. I mean, look at us. Look how close we are to 115,000 people. Should we take a commercial break, a sponsor break? Let's take a sponsor break. This next segment, everybody, is brought to you, wink, 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 parody incoming, by Cluvelta. Are you constantly narrating your own life like it's a Dateline episode? Do you whisper, "The husband did it," at weddings? You may be one of the millions silently suffering from a condition known as true crime brain syndrome, or TCBS. But now there's hope. Cluvelta, the first semi-legal, questionably tested treatment for TCBS. Cluvelta helps restore balance to your life by gently replacing your obsession with murder with an obsession with real estate shows. Cluvelta users report fewer murder boards, shorter Reddit rabbit holes, and an increased ability to trust their spouses again. Maybe. Side effects of Cluvelta may include watching cooking shows and actually following the recipes, trusting your neighbors not to be serial killers, starting a knitting club, and accidentally solving local crimes anyway, hallucinations of Keith Morrison narrating your dreams, and in rare cases, mild interest in HGTV. If you experience sudden urges to say, "Let's circle back," or "This doesn't add up," discontinue use immediately and call your podcast co-host immediately. Cluvelta, because even you deserve to sleep without checking your Ring camera 12 times a night. Special thanks to Cluvelta for this next segment. Here we go. Let's go back to the doc, the legal argument. Here we go. By the way, I did see a comment that I thought was really good. Let's see. Where was it? Basically, it said the government does not grant rights. The Constitution protects rights. And that was what the founding fathers said, right? There are certain inalienable rights, and they are self-evident. And so that's why I phrase that as our rights as guaranteed by the Constitution. The Constitution doesn't give anybody's rights. It just guarantees rights that you already have. Okay. Bring this back up. I was pushing funny buttons during the commercial. I hope that didn't bother anyone. Let's bring up the sub count. It's pretty fun. All right. Here we go. Legal argument. The warrantless seizure of Mr. Stern's cell phone was unconstitutional. The Fourth Amendment protects against unreasonable seizures of property even when no search has taken place. A seizure of property occurs when there is some meaningful interference with an individual's possessory interests in that property. The instant matter presents precisely such a meaningful interference as Detective Tagler unilaterally seized and retained Mr. Stern's cell phone for over 9 hours without consent or probable cause. That's what they're arguing, right? That no probable cause existed. So the prosecution will have to make their argument about that. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitutional is coextensive with Fourth Amendment jurisprudence. While law enforcement may temporarily seize property to prevent the destruction of evidence while seeking a warrant, such seizures must be properly limited in scope. And this is really important, guys, because, for example, say, I don't know, I'm at my house, or I'm coming home to my house, and it is surrounded by police cars. And I go, "What is going on? I am the owner of this house." And they say, "Oh, Mr. Fish, we really need to get inside. Will you give us permission to go inside?" And I would say, of course, because I'm not stupid, I do not consent to you going inside my house. Then they may say to themselves, or say to me, "Okay, well, we're going to apply for a search warrant. You may not go inside until we have been granted or denied a search warrant." But they have to do it then. They have to write that application, get it to a judge. It has to be a reasonable amount of time. Okay, the Supreme Court held in place that even when supported by reasonable suspicion, the 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed unreasonable in place. place being the case, right? The Florida Supreme Court's analysis in Golphin v. State further illuminates why the seizure here was unconstitutional. In Golphin, the court examined whether retention of identification during a brief warrants check constituted a seizure, emphasizing that not all encounters between law enforcement and individual citizens constitute seizures, but rather courts must examine the totality of circumstances to determine if there was meaningful interference with possessory interests. Unlike Golphin, where officers merely retained identification briefly during a consensual encounter, Detective Tagler effected a full seizure by unilaterally announcing she was taking possession of the phone without seeking consent, retaining it for over 9 hours, and completely depriving Mr. Stearns of his ability to communicate with family members. By the way, Mr. Stearns should have said, "I do not give you consent to hold on to my phone." They would have held it anyway. But the consent, the specific and expressed lack of consent would have been on the record. Blah, 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 blah. Okay. The extended duration and complete deprivation of Mr. Stearns' possessory interest in his phone demonstrates why this case falls squarely within Place's holding that even brief investigative detentions of property must be properly limited in scope and duration. Detective Tagler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure. Instead, Detective Tagler retained the phone for over 9 hours without providing any indication of when or how it would be returned, far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. The length of the detention alone precludes any argument that this was a properly limited investigative detention under Place and its progeny. Hey, by the way, I think I said something wrong earlier. If you tell a police officer that you do not give consent for them to seize your property or search your property or person or whatever, they cannot use that as the probable cause. They may in their mind go, "Ooh, cockles are raising," right? Suspicion is getting more aroused. It has been longer than 4 hours. I must seek medical attention. No, that might happen, but they can't use it as probable cause. There has to be something other than you saying, "No, you can't search. No, you can't seize. I do not give consent." And I think that I misspoke earlier. I misrepresented what the law is. Okay, the initial seizure extended the scope of any purported consent. While consent provides an exception to the Fourth Amendment's warrant requirements, such consent is strictly circumscribed by its express scope and circumstances. The United States Supreme Court has established that the standard for measuring scope of consent is one of objective reasonableness. This part is important. Specifically, what would the typical reasonable person have understood by the exchange between the officer and the suspect? This objective standard protects against the law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. The reasonable person standard is super, super important in law, guys. This is when you're on a jury and you're determining if there is reasonable doubt or if they have proven beyond reasonable doubt their case, let's say the prosecution or the plaintiff, then that reasonableness standard, okay, what would a reasonable person expect? What would a reasonable person understand that to have been? Would it cause a reasonable person to change their behavior or change their direction? Right? Those are the questions that are asked. It's a very important legal doctrine. Florida courts have consistently enforced strict limitations on the scope of consent, recognizing that permission granted for one limited purpose cannot justify broader government intrusion. In Appelt v. State, the 5th District Court of Appeal held that consent to enter a home to check on well-being did not authorize a full search of the premises. Correct. Similar in State v. Wells, the Florida Supreme Court determined that consent to search a car trunk did not extend to closed containers within that trunk. These decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. In the instant case, meaning in this case that we're talking about here, Mr. Stearns provided extremely limited consent for Detective Tagler to go in your settings real quick solely to see if you're logged onto Google. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5-hour retention of the device, which I believe is a valid argument. Detective Tagler's unilateral announcement that she was, quote, going to hold onto your phone, close quote, and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Stearns' limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Appelt and Wells. Just as consent to look in a trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. That is a fine argument. It's a compelling and convincing one. And I hate to say it because I believe that he committed this crime. But the law is the law, and we want to make sure that law enforcement officers follow them. Okay. Where are we at? The unreasonableness of interpreting such limited consent to authorize extended seizure is particularly apparent given the Supreme Court's emphasis in place that even brief investigative detentions of personal property must be strictly limited in scope and duration. When Detective Tagler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed. The prosecution is going to argue otherwise, right? Rendered the extended seizure unconstitutional under both consent and general Fourth Amendment principles. Okay, part 2. No exigent circumstances justified the extended seizure. While law enforcement may conduct a warrantless seizure when exigent circumstances exist, such circumstances are, quote, few in number and carefully delineated. This is in Welsh v. Wisconsin. The state bears the burden of demonstrating that the procurement of a warrant was not feasible because the exigencies of the situation made that course imperative. And it makes me wonder if they're going to argue that, well, they were using all their resources to find Maddie this time. So, you know, we couldn't go for a search warrant because we were just really, really looking for Maddie. I wonder if that's one of the arguments they'll make. None of the recognized exigent circumstances existed here. First, there was no hot pursuit of a fleeing suspect that would justify the warrantless seizure. Mr. Stearns was at his residence and fully cooperative with law enforcement when Detective Tagler seized his phone. He made no attempt to flee or evade the officers. Second, there was no imminent destruction of evidence. Detective Tagler articulated no specific facts suggesting Mr. Stearns was attempting to or about to delete data from his phone. In fact, I think the fact that he hadn't already, after Maddie was killed, is probably a good indication that he hadn't even thought about that. Indeed, the phone had already been factory reset prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent the destruction of evidence. The mere possibility that additional digital evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. Whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened. And again, I think that is a good argument. Well, I'm really looking forward to seeing what the state of Florida, how they respond. Third, no emergency aid circumstances existed. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. That was the question that I just had. Okay. And I have not read this before. Wow. Okay. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable basis to believe that an emergency exists requiring immediate action to prevent imminent harm. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5-hour warrantless seizure. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 8 p.m. on February 26th, yet Detective Tagler did not seize the phone until 4 p.m. on the 27th, some 20 hours later. This significant delay undermines any argument that immediate warrantless seizure was imperative. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. Even assuming arguendo that emergency circumstances initially justified seizing the phone, arguendo just means arguing. I don't know why they do that. Okay. So even assuming that the argument is that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life and render first aid, provided they do not enter with an accompanying intent either to arrest or search. Detective Tagler's own statements reveal the investigative purpose behind the seizure, as she explicitly told Mr. Stearns, quote, "I told you I was going to hold on to it and that we would like to download your phone, right?" Which she did not say, to my memory. I don't think that she said we want to download your phone in the first thing, but correct me if I'm wrong. Demonstrating from the outset that her intent was to conduct a forensic search rather than address any emergency. Once the phone was secured, any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tagler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Indeed, so they did not attempt to search it. That is my misunderstanding. All right. Instead, law enforcement simply held it for over 9 hours before seeking consent for a forensic examination. This behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under the emergency exception, the person making entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within. Guys, I'm going to go back here. I honestly think that she was scrolling through the phone looking at stuff while her partner was keeping Stearns busy. I think so. I think the lawyer is just saying that didn't happen because there's no record of it happening. Okay, this objectively reasonable belief must be based on specific articulable facts. And in fact, the officer, if she did that, could not have admitted that she did that in a report because that would be a admission of an illegal search. Okay. This objectively reasonable belief must be based on specific articulable facts and reasonable inferences that could have been drawn therefrom. Here, Detective Tagler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent imminent harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an objectively reasonable belief in an emergency requiring immediately warrantless seizure of the phone. Fourth, there were no community caretaking circumstances requiring immediate action. The phone itself posed no danger to the public, and its seizure was clearly investigatory rather than for community protection purposes. They're going to keep on going through all the different exigent circumstances. Okay, let's go here. All evidence derived from the unlawful seizure must be suppressed. When consent is obtained after illegal police activity such as an unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. The consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official illegal action. The fruit of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. Again, that is a famous case, Wong Sun v. U.S. The relevant inquiry is whether the evidence was obtained by exploitation of the initial illegality or by means sufficiently distinguishable to be purged of the primary taint. That's what we talked about earlier, right? If there's some other way that they could have gotten to that, or they did get to that without that poisonous fruit, then they can get around it, right? The Florida Supreme Court has consistently held that evidence discovered by exploiting previous illegal conduct is inadmissible. See Craig v. State. Here there was no break in the chain of illegality between the unconstitutional seizure and subsequent searches of the phone. The extended deprivation of Mr. Stern's phone created coercive circumstances that led to the midnight consent for its forensic examination. Any purported consent was inexplicably intertwined with and the direct product of the illegal seizure. The Google warrant and all derivative evidence were direct products of the initial unlawful seizure, and as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom must be suppressed as fruit of the poisonous tree. I'm going to say this now so I don't forget. If they lose on this, like if the defense loses on this, this will be the foundation for decades of appeals. I mean, it's that important. Okay, the conclusion. Detective Tagler's warrantless seizure of Mr. Stern's cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. The 9.5-hour deprivation of an essential communication device without consent or exigent circumstances violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations, wherefore we submit it, blah, 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 blah. Whew. Guys, I think that's a compelling argument. I think they are making compelling arguments here. My goodness. All right, let's go over to your comments here. I'm probably going to miss a whole bunch of them. Sorry, guys. But we are going to... Can we assume they already found Maddie's stuff in the dumpster by this time? That would change the level of urgency. I don't remember the timeline there. So I can't make that assumption, but it's a good question. Would this situation put other cases where these detectives have worked under scrutiny? I don't know. In this case, no, I don't think so. I mean, there might be some defense lawyers or some appeals lawyers that would go, hey, wait a minute, did this happen to my client? And they might look into it. I guess it's possible. But will it cause an avalanche of appeals based on the fact that the detectives may be found to have done something illegal here? I don't think so. Susan says, exigency can include seizing to prevent destruction of evidence. The police did not know that Stephan Stearns had reset his phone prior to seizing it. I think they did. He told them he did. And I think he told them before. I don't have it. I don't have the transcript up. I can't verify that, but I think so. Derek, tonight on Gavin Fish, catch and release. That's funny. T-Boz says there's a loophole. They held his phone, and I'm pretty sure he consented to it, if I remember correctly. I don't think he consented to it until later, like in the early morning hours. That's what the defense attorney is arguing anyway. And I think she's right. Yeah, just 12 more subs to 115. So cool. Yvonne asks, Gavin, is Cluvelta safe for dogs? Mine are barking at a perfectly legit-looking gentleman in a mask who only wants to use my phone. I don't know that it's been tested on our canine friends. I do not allow any type of sponsorship or support on my channel that would cause animals to be tested upon in any type of laboratory anyway. This is for humans only, okay? Pooh's Blustery Day says, Gavin, thanks for your coverage. It's a good distraction from all the tornadoes and flooding in Kentucky right now. Ooh, well, stay safe, Blustery Day. Patty says, I thought he gave them consent verbally to download his phone. He did after the 9.5 hours. Yeah, I think, let me just keep on going up. Marco Benavides, Gavin, so is the state now given chance for rebuttal? Yeah, so what will happen is the state will submit a written response to the motion, and there is a hearing that is scheduled for April 23rd for the judge to hear oral arguments. So yeah, there's going to be a lot. We're going to be able to read the state's response to this. Remember, this is just what the defense is arguing. It's very one-sided. I think it's a compelling argument in many ways. But I am also not a judge, nor am I a lawyer. I never even came close to going to law school. So, yeah, I do know. I don't know if you guys are on TikTok, there's this couple they're young lawyers. Both of them are Harvard law graduates, and they, comment on different things that are happening online. And when they ask questions, is it legal to do this? Or was it legal? Or was it illegal? They always go, it depends. And then they go into their, analysis. And that is the way the law is. Is it clear cut? No, it depends. It always depends. So, yeah. Stacy says, Gavin, he did consent in the car the night they were searching the house. We heard the recording. The detective said she was going to get the warrant if he didn't. And I think that's the later. That's the thing that we listened to. That's the recording we listened to. That was later after the 9.5 hours. Him resetting his phone, probable cause. Missing child, probable cause. Ugh, this is frustrating. I don't know that your position there is legally accurate. But I don't know because I'm not a lawyer. I have no idea. Stephan Stern, says Joy, answered yes to the obtain of the phone. And remember, he said, oops, sure, but I tried to. Okay. I think that's where we will stop, guys. It is a very interesting. It's a very interesting wrinkle in this case, and I know that a lot of us that are commenting on YouTube and on social media and other platforms, TV and so forth, are saying, no, this is a nothing burger, right? This isn't anything. But no, I think that's a pretty darn good argument. And we all should be very concerned if the police did what is alleged by the defense here. Because if it can be done to one, it can be done to all. We want everybody to be secure in their property and their person. That is something that is guaranteed by the Fourth Amendment, right? So it's guaranteed. What amendment guarantees us to? Yeah, The Fourth Amendment guarantees the people to be secure in their persons, houses, papers, and effects, protects us against unreasonable searches and seizures. So we want that for everyone. Hey, for those of you on the live stream, it is Friday. We are not going to be going live this weekend. I am hoping that over the course of this weekend, I am going to be able to make the change in my office that is going to make this look radically different for all y'all. I hope you're okay with that. With the summer coming and this old Tiffany window on a south-facing house, man, it gets way too hot in here. So we're making changes in my accommodations for my office and live streaming studio, hopefully over this weekend. And we'll be back on Monday to continue our discussion of cases that are relevant here in true crime. Let's just check sub count one more time here, see if we're a little closer. We're a little closer, y'all. That's pretty fun. Yeah, we're getting close to 115. That's pretty awesome. Okay, before we go, just a quick plug. Remember, you can get your Cluvelta merch and other merch over here on the website, gavinfish.com. Thank you very much to those of you who have ordered merch. That each time you do that, I get a couple bucks, and that really helps in supporting me to continue to do this and hopefully be a full-time YouTuber someday. The next thing that I want to bring to y'all's attention, always come join us on the Fish Tank if you're on Facebook and that's your thing. Just search Gavin Fish True Crime. You'll find it. Also, remember that all the cases that I cover, not all of them, but most of them have really deep case pages, including this one, Madeline Soto. We have so much. Oh, I need to make that just a little smaller. There we go. Oh, too much, Gavin, too much. There we go. So if you want to take a look at the case page, you can do that. Special thanks to my patrons who support me, make it possible for me to have the website here. Check out Crime Cod, which is a true crime website. We publish articles every day in the true crime world. And then what was the last? Oh, don't forget that in June, I don't know, at least in the top 200 favorite YouTubers, am going to be at CrimeCon UK. Let me show you this. Bring it up. Here is the full schedule on Saturday, the 7th of June, as we get to prime time. Me and my buddy. Where are we at? Almost. There's Colin. Oh, we're almost there. We are. Boom. Me and my buddy Joseph Scott Morgan are going to be making a presentation at 5 p.m. on the main stage there in London, June 7th. If you find yourself either living or visiting across the pond, come check us out at CrimeCon UK. It is a blast. It's much smaller than CrimeCon here in the States, usually 500, 600, 700 guests, and we just have a good time. And I've made some just really, really close friends at CrimeCon. So come check us out for that. And I guess with that, guys, I'm going to bid you adieu. Thank you very much for joining me, and I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.